At the Supreme Court this week, the Supreme Court reminded that while moneylenders can acquire properties used as loan collateral, ownership cannot be automatically transferred to them unless there is a separate agreement. In a decision written by Chief Justice Alexander G. Gismundo, the Supreme Court First Division upheld the transfer of ownership of the land owned by Ruby Shelter Builders and Realty Development Corporation to its creditor, Romeo Y. Tan and Roberto L. Oviedo. The SC held that this transfer was based on a valid agreement and did not violate the law prohibiting the automatic transfer of collateral ownership. Ruby Shelter borrowed money from Tan and Oviedo, using several properties as collateral. When the outstanding debt reached 95 million pesos, the parties signed a Memorandum of Agreement or MOA to sell their properties to Tan and Oviedo as payment for the loan. The Supreme Court upheld the validity of the MOA and held that Ruby Shelter voluntarily entered into the MOA to sell the subject properties. The court also explained that the MOA does not constitute a pactum commissorium or a prohibited agreement under Article 2088 of the Civil Code. This provision states that a lender cannot automatically obtain ownership of the collateral if the borrower fails to pay. A pactum commissorium occurs when 1. A property is used as collateral for a loan, and 2. The loan agreement includes a provision automatically transferring ownership of the collateral to the lender if the borrower fails to pay. In another case, the Supreme Court emphasized that search warrants must clearly define the location to be searched. Otherwise, they are invalid for violating the right against unlawful searches and seizures. The Constitution requires a valid search warrant to particularly describe the place to be searched. This requirement is crucial to prevent enforcing officers from deciding on their own where to search and whom and what to seize. The SC also stressed that government agents must first identify themselves and ask for permission to enter the place they want to search. They can only force their way in if they are denied entry. This rule protects both the person being served with a warrant and the agents from possible violence that could happen from an unannounced entry. Additionally, searches must be made with the lawful occupants of the house as witnesses, or if they are unavailable, two residents in the same area. This decision of the SC Second Division, written by Senior Associate Justice Marvic MBF Leonin, acquitted Lucky Enriquez of the crimes of illegal possession of dangerous drugs and drug paraphernalia under Republic Act No. 9165 or the Comprehensive Dangerous Drugs Act of 2002 due to a defective search warrant and its irregular execution. The Office of the 2025 Bar Examinations Chairperson, Supreme Court Associate Justice Amy C. Lazaro Javier, has reminded that the Bar Applicant Registration Information System and Tech Assistance, or Barista, may be accessed beginning 8 in the morning on January 8, 2025 for applications to take the 2025 bar examinations. The application period will be until 3 in the afternoon on March 17, 2025. For bar bulletins and other information about this year's bar exams, you may visit the Bar 2025 microsite at the Supreme Court website, sc.judiciary.gov.ph. Meanwhile, the Office of the 2024 Bar Chairperson, Supreme Court Associate Justice Mario V. Lopez, reiterated that the oath-taking and roll-signing ceremonies for the 2024 bar examinations shall take place on January 24, 2025 at the SMX Convention Center, Manila in Pasay City. A total of 3,962 passed the 2024 bar examinations for a passing rate of 37.84%. The 2024 bar examinations were held on September 8, 11, and 15, 2024 in 13 local testing centers in the National Capital Region, Luzon, Visayas, and Mindanao. The 2024 bar examinations were the 122nd professional licensure tests conducted for aspiring lawyers in the Philippines. And that's your Supreme Court this week. I am Tiffany Dobletran, Supreme Court Information Officer.